This is the antithesis.
We don't want to get bogged down on one case because I
understand
deal with hundreds of thousands of cases. I appreciate it.
But it's the principle.
But the principle in this, as I understood it, was that for 8 weeks, Mr.
8 months.
Short paid lawyers saying, you know, you're wrong.
8 months.
Sorry?
8 months.
8 months. Sorry. You get to the first day of the hearing, and the tax office lawyer gets up and says, "Yep, you're right. We made an error. Sorry, we're withdrawing."
And that's process.
And that's model litigant. You know, a model litigant would have said 8 months previously, "Yep, you're right. We have made an error. Don't like to admit it, but we've made an error. So let's finish it there and then."
Yes, I'm not sure about how it's been characterised making an error. The issue was the procedural fairness issue about whether the employee issue, which was raised 3 weeks out from the full federal court hearing.
You're talking merits of the case.
No, we're talking about the process.
process.
If you read the full judgments of the AAT, the federal court and the full federal court, you'll see that what happened was the AAT made a decision on the evidence before it, which it's fully entitled to do, even if it's evidence that wasn't before the ATO, and it's a much more complicated situation than the way it's been portrayed. If you go through the full evidence, I mean, ideally maybe a concession might have been made earlier, but in the end, Mr. Short had made certain submissions and there was evidence before the AAT it had to deal with, and he had made submissions on those things. It's a very unfortunate sort of a case, but I think you've got to go right through all the decisions.
But even, look, the point is, if you accept Mr. Short's evidence, and maybe you don't, but on what he tells us, you get to court for the day of trial and your lawyer gets up and says, "Yep, look, as he's been claiming all along, we've made an error, so we're withdrawing." Now, all I'm saying, a model litigant would have decided 8 months previously that they'd made an error and withdrawn. And most litigants, you know, Mr. Short's obviously determined and has some means at his disposal to do it, but most citizens would just
Senator, can I just read to you? I mean, the full federal court said that there's no...
Sorry, but my point is,
yep.
Did your lawyer on the day of the hearing
of the full federal court
get up and say, "Yep, sorry, we're withdrawing because we made an error"?
In the full federal court, our lawyer conceded on the point of the procedural fairness point, on the employee point.
Why didn't he do that 8 months earlier? That's the procedural fair. That's the model litigant. You know, a model litigant who didn't have a personal interest in it, and of course no Commonwealth employee does. You're acting for all of us. But if he's going to get up on the day of the trial and say, "Okay, his argument's right, we're withdrawing," why didn't he do that 8 months earlier?
Well, suppose it comes down, I suppose, to the jurisdiction of the AAT. The AAT...
No.
But can I explain why it happened at the last minute? The reason is because before the AAT has jurisdiction to hear the matter from the beginning. It doesn't... Whatever the Commission's opinion doesn't matter. So if the Commissioner goes in there and says, "We're not going to make an issue about employee," that doesn't bind the AAT. The AAT can still make that decision, which it did. And the AAT said that Mr. Short was an employee. And when that went on appeal to the full federal court, Justice Gilmore was aware of that with what had gone on, and he upheld the federal court the AAT decision. It was when it went to the full federal court, and the full federal court 3 weeks out, the procedural fairness point about the employee issue wasn't articulated until 3 weeks out for the full federal court hearing. That's the reason why the court didn't grant costs to Mr. Short. It said each party pay its own costs.
And in fact, our counsel and our solicitors endeavoured to point out the defects in Mr. Shaw's appeal points, and that these issues weren't raised properly, repeatedly during the interlocutory process.
Why did they withdraw 3 weeks later?
Well, because sometimes these things have to be resolved at the hearing. And I'd remind you, as we've stated previously, that the majority judgment expressly dissociated themselves from the comments of Justice Logan and said that there was no breach of the model litigant guidelines.
Our conduct was...
So why did you withdraw?
Because in the end, it was expeditious to do so at the hearing, having regard to that. But we had sometimes it's got to go before a court to get to that point. There was various correspondence we sent to Mr Douglas's lawyers pointing out those problems. No, we sent to them pointing out the defects in his appeal.
But in the end result, you agreed with him. You withdrew on the eve of the on the first minute
on
of the
the procedural fairness point, because we could see, if you minded from the court, the employee issue had been determined. Sorry.
Well, litigation is tremendously difficult and complicated a lot of the time. You can't say there's got to be some standard of immediate perfection and everything has got to be done always perfectly, because it's just not going to happen like that.
Senator Helm and I, many years ago, and not very good, were lawyers. I understand a lot of those things.
Yeah.
But I understand too that, you know, if you've got the money, you can take people to the door of the court and hope that they'll concede and roll over. But if you have the money and the expertise to go on, you know, very often the other side will then say, shit, they've got us here.
But Senator, can I just say the issue wasn't determined on the substantive issue wasn't determined on that issue. Yeah. But it wasn't determined on that issue. Probably that's why it became didn't suppose it wasn't articulated till the end. But
can I get off Mr Short's circumstances and talk about the bill per se?
Yep.
I've been trying to discern your objections to it. From both your oral submission and your written submission. And delays and costs are the two main objections that I can see. And you also note, you think that there are existing provisions, in particular interlocutory and cost orders. Have I summarised that accurately?
Yes. Right. Cost orders,
okay. So
references to...
delays and costs on that point. This was raised with earlier witnesses, and there would be instances where a delay would add to the cost of a party to an action with a Commonwealth agency, including the ATO, and it may disadvantage them. A delay may disadvantage them. Additional costs of a delay may disadvantage them. However, I'm pointing out to you that the onus for whether or not to invoke the model litigant provisions rests on that party. It doesn't rest on the Commonwealth. So if a party wanted to raise breach of model litigant rules in an action in which it was engaged with the Commonwealth, that would be its decision, not the Commonwealth's decision, and the consequences of that, they would, you would expect, would hope, that they would acknowledge that if it did result in additional costs, that would be, they were aware of that possibility. So why is that a problem from your point of view?
Well, there will be parties who will want to bring collateral challenges to...
Say again?
There will be parties who will want to bring and will bring collateral challenges to try and impede the finalisation of the taxation matters and do so outside the proper Part 4C tax appeal.
So the relevant issue is, Senator, is how is that going to determine the tax issue?
It's not. It's
that's right.
Not intended to.
Well, why bog down the tax issue then? Why bring that delay into...
Because what the allegation would relate to, what the concern would relate to, is the behaviour of the Commonwealth on the other side of the dispute. So, for example, if the ATO was a party and its legal representatives were failing to comply with discovery orders, invoking public interest immunity, using technical points, denying facts which are known to be true and requiring the other side to prove them, just as examples. They don't go to the merits of the case, but if those sorts of complaints were made, if this bill was law, the party involved could then go to the Ombudsman and say there's been a breach of model litigant. The Ombudsman would have a period of time in which to report to the court. The Ombudsman report would go back to the same court. There would be no change in jurisdiction, no change in court, back to that same court, and the court would then be informed about that. The court would then decide whether to do anything, if anything, in light of the Ombudsman's advice.
But those sort of things you've just recited, not complying with discovery orders and so
Court
on,
already
if
has
that
those.
was going on, we would have court judgments saying those sort of things were happening, interlocutory judgments.
The court can already do that.
That would not go unobserved. Serious breaches
court
of
has-
that kind would be on the public record in court decisions.
All
Your
the
own,
things you
your
just
own
mentioned.
submission says 14 breaches of model litigant obligation are investigated and finalised, 2 confirmed findings of model litigant breaches by the ATO. Both cases, these were procedural. I mean, failing to comply with discovery orders is pretty procedural as far as I can see.
I don't. Well, I reject. I'm not aware of any allegations of failing to comply with discovery orders.
if the ATO
that would go back to the court on an interlocutory hearing,
The court
and
already
it
has
would be
that
on
power.
the public record. The court would take failing to comply with the discovery order very, very seriously, and it would be on the public record. So,
And the court would order costs against the commissioner. I mean, the cost, everything you mentioned, Senator, everything you mentioned in the before is everything that a court already has jurisdiction over.
and I'm not aware of any evidence of those sort of things happening.
Okay, in that case, you should have no objections to the bill because you're already behaving as model litigants.
As I said before, it will give certain taxpayers the opportunity to run collateral procedural challenges that will impede
60 days.
Impede-
They get to avoid paying their taxes for 60
a
days.
substantial amount of time in
Yeah, but if you could have, I mean, what we find more and more in our significant litigation, particularly with egregious taxpayers, is the use of interlocutory procedures to delay the litigation. This is a classic situation where an egregious taxpayer, not the mums and dads, small business individuals, egregious taxpayers will take advantage of this legislation to delay proceedings by collateral attacks on conduct which is not relevant to determination of the tax issue.
For what purpose would they want to delay it by 60 days?
We'll be more. There'll be appeals and cross appeals and so forth.
So what's the advantage? The result will be the result eventually. What advantage
Well,
do
it
I
adds
get
to
by-
the cost of the Commonwealth, makes it much more difficult for us to run litigation.
Well,
We have this.
you talk about the cost. What about the cost to mums and dads and those who have to enter into contest with the tax office? You cannot. An ordinary person cannot afford to go to court.
But that's the whole
but
point.
The tax office can.
Why
And
have a
doesn't
Well,
have to-
the AAT is a cost-free proceedings. We have run lots of matters in the AAT with
with
minimal costs
counsel,
for
with
taxpayers.
QCs.
But not in the AAT, no.
Not in the AAT.
Yes, you do.
Taxpayers can be unrepresented. We are often
Taxpayers can be.
and we are often unrepresented. We often represent ourselves with relatively junior officers in the AAT all the time.
Non-lawyers.
They've usually got legal training, usually.
But the expectation...
And so they should, because if they've got to comply with things like the model litigant obligations, of course they should have legal qualifications.
So the question is, the expectation of the legislation is that people can, that a taxpayer or can basically delay or delay the proceedings, get a stay to determine an issue that's not related to the determination of the substantive issue. Most of the legislation, most of the states and territories that has established their courts and tribunals explicitly have provisions about trying to get cheap, just, efficient determination of disputes. And it just seems to me that this will be a distraction from the determination of the substantive issue. The issues you talk about, discovery and so forth, the court already has those powers. The court can order that cost orders. It can put guillotine orders. There are many things it can do. So the legislation basically seems to it's just going to add cost and delay, and the people that are going to get hurt are the small business and the individuals, not the egregious ones who will take advantage of it.
Mr. Tanner, I find it interesting that you're arguing that it will unnecessarily delay things. I presume you are familiar with the letter that the Second Commissioner of Taxation tabled to estimates this week, addressed to Ms Helen Patea.
We didn't table it, she did. Well, she says...
Oh, I see, okay, all right, I'm corrected. Relates to a dispute which commenced in 2011, which now in October 2018 has led to an apology on the part of the ATO well, I don't need to go into the details of it, but my point is, of course, that it is a bit rich for the ATO to be saying a taxpayer who is disputing an assessment will unnecessarily delay things under the circumstances in comparison to this case.
Well, what I would say about that case is I prefer not to make further public comment on it because it does not assist resolving it. And what I would say generally about those sort of cases and some of those submissions that have been made is that those taxpayers are not in dispute with us over compensation or damages, although some of them have said they are. Now, with cases like that, we have obviously got to try and resolve the dispute as expeditiously as possible at a minimum cost to the other party and to the Commonwealth, and we've got to have regard to the risks and costs of litigation and meaningful prospects of liability. And we have to obtain external legal advice for compensation claims over $100,000. And in expending public money, we have to adhere to the principles of the Public Governments and Performance and Accountability Act, the Legal Services Directions, and things like the guidelines on the CDDA scheme. Now, in those sort of cases, we make appropriate offers to try and compromise and settle the disputes, having regards to the requirements of all those laws and guidelines. But in the end, it takes two parties to settle a dispute. And where the other party is claiming millions or tens of millions of dollars, and we're not able to identify a legal or principled basis to make a payment of that magnitude, we can't really bring a settlement into being. And we're left with all we can do is explain our position, and we can't make a settlement happen beyond what we're authorised to do in those sort of cases.
All right, so...
Oh, just whenever.
Yeah, well, I'll defer to you. You go ahead.
Okay, thank you. Mr Todd, you're the General Counsel. You introduced yourself first. Mr Tanner, I didn't get what your...
So Assistant Commissioner for Litigation.
Thank you very much. I guess, as not being the only, just about the only non-lawyer in the room, you're going to have to help me with a lot of these points. It seems to me that it's critical, and we've heard from other witnesses, that the point at which a dispute attracts model litigant obligation is a factor. Is that a fair point to make?
What was that? Sorry.
The point at which a dispute attracts model litigant obligation. Is that a fair point to make? Where do you see the model litigant obligation coming in?
As soon as someone indicates they want to bring legal proceedings or make a claim against the Commonwealth.
Okay.
And potentially in the way we would decide an objection as well. We would have regard to those sort of principles.
Or if the Commonwealth initiates...
Well, the tax office doesn't really... I'm speaking from the tax office's point of view. We don't really initiate very much litigation. It's mostly brought against us. So, yes, that would be true with the Commonwealth initiating litigation where it did so, but I can't really speak to that.
Recovery action is not litigation?
Oh, sorry, well, other than recovery action, I'm talking about the Part 4C tax action, yes.
Oh, yeah.
No, sorry,
Recovery action, yes, then that's right. Yeah.
Yes.
So do we issue?
Sorry.
Yeah.
Thank you. Thank you. I'm speaking here, I'm trying to get to the process part of it. Please excuse me if I go through a number of cases that are important, that are my constituents in New South Wales. And they've certainly given me permission to mention names, and we've been mentioning names before. And they will put in a late submission into this, and that will be good. I'm talking about model litigant here, and I'm speaking under privilege here, but I think it's fair. I think what I say will be fair. So I'll have some preliminary comments and then a couple of questions, if I may. Your para 14 of your submission that Senator Leyonhjelm has mentions that you've had 5,000 legal proceedings, 456 appeals, 14 breaches and which have been investigated and finalised, and 2 confirmed findings of breaches by the ATO. I wondered over what... I don't think you mentioned it, over what period of time, please.
That's paragraph 11.
Since when? 11.
It's paragraph 11, not 14.
I apologise. Paragraph 11. Yep. What did I say? 14.
I'm looking at the version
Paragraph
I
11.
have here is paragraph 13.
11.
Yeah, paragraph 11. My apologies.
Oh, okay, I've got a different version.
There's supplementary submission.
This is their response.
Paragraph 13, that's you're referring to, Senator?
No, paragraph 11 I'm referring to. My apologies.
This is
It's up of your second submission.
it's the response to Mr. Short's.
Response to Mr. Short
Oh, okay, sorry. One moment.
and other information.
Submission, their response.
The response to Mr. Short.
We can refer to this, can we?
I think it's the same as the other paragraph in, yeah. Look, I don't seem to have that with me. I think it's the same as paragraph 13
of our
original
principal
submission.
Oh,
Yes.
submission.
We'll try and work from that. And
Pure
see how we go.
coincidence. It says, for the record, it says in 2016-17, the Commissioner of Taxation was a party to over 5,000 legal proceedings, including 456 tax or administrative law appeals. And then perhaps, I'm just looking down here to where it says that there were 2 confirmed findings of breaches by the ATO. 14 breaches investigated and finalised, 2 confirmed findings of breaches by the ATO. That's in that 1 year?
Yeah. So in the statistics I can give you are in 16-17, 14 reported breaches, 2 confirmed breaches. In 15-16, 16 reported, 7 confirmed.
16, 7 confirmed, okay.
14-15, 16 reported, 8 confirmed. 13-14, 23 reported, 3 confirmed. 12-13, 29 reported, 2 confirmed.
2 confirmed,
So
okay. Thank
maybe
you.
I'll give you the year to date too. Just one moment. I'll just get that. Hopefully. The year to date we have 7 reported and no breaches found, 3 no breach found, none a breach found, and 5 still under investigation.
Okay, thank you, that's good.
And Senator, can I just give that context?
Sure.
In the 2017-18 year, the one just ended with there were 36.5 million returns lodged.
Yep.
Objections 24,300 determined. Objections disallowed 2,000. All matters that went to court, including recovery action, 5,000, about 6,000 matters went to court. And of those tax disputes, in terms of the Part 4C, there were 337, of which 102 were in the AAT.
That's a pretty good record, isn't it?
So, just to give that
Compared
context,
to the number of activities that you conduct. And what does confuse me a little bit is that from the evidence we've heard, some in camera but some in public, and what my constituents are saying to me, and I've only got 4 of them, and I don't know whether you may consider this 1 or 2 or 3 or 4 of the cases that you mentioned, but I think it's fair to say that they were failures, and when you took someone called Ron Pattenden to court, Gary Kurzer and Joanne Hambrook, and required Federal Police Officer Nick Berry, who then took you to court. And in these instances, I think it's again fair to say that was great hardship caused, enormous stress and expensive disruption to the parties concerned, before the ATO had to pay out substantive monies and or compensation to them, although Hambrook's case remains to be finalised. And I'm just using this as the basis for trying to get to the process that the bill is all about. It seems to me that in each instance, taxpayers' money was wasted in legal fees and time and resources, and you've said that what you're on about here is delays and costs, which is your objection to the bill. You want to reduce costs and delays and achieve efficiency, and I guess what I'm talking about here is a perceived justice issue. In each instance, taxpayers' money was wasted in legal fees and time and resources when pursuing revenue from what turned out to be hopelessly wrong assessment raised in ATO's favour, which stood no chance of standing up to judicial scrutiny. Now, that's a judgment made by someone else. And just let me go on for a minute, if you would. I'm informed by one of them, by Mr Berry, that the High Court ordered the ATO to pay Pattenden about $5 million. Are you familiar with that, Pattenden's case? No. After you appealed the related federal court decision made against you to the High Court with it's claimed here with no prospect of winning. Other federal Government agencies such as the AFP and others are required to submit evidence to an independent arbiter for review, and I know we're talking about the Ombudsman here and you're talking about the AAT, such as the Commonwealth Director of Public Prosecutions, before proceeding to court. And here comes the question. The question really is what is your objection as a model litigant to having disputed assessments independently umpired by an outside the ATO body, such as the IGI, the Inspector for Taxation, or someone such as a discrete tax tribunal for small business plus prosecutions be taken away from the ATO and put under the AG's department?
Well, the AAT already is an independent review tribunal, and it's an administrative review tribunal, so it stands in the feet of the original decision maker. So, I mean, it's a policy matter for government as to what and how it wants to, say, maybe change the AAT, and I would have thought that was the appropriate thing to be considering. I mean, in the end, you've got to have regard to the constitutional powers of the Commonwealth, so you've got to vest judicial power in the judiciary and so on. You can have a body like the AAT that's an administrative review tribunal, and that's there. I mean, it's a policy matter for government as to how they might like to make the AAT more effective, perhaps, for small business. And we used to have a small tax claims division of the AAT and a small business claims tribunal of the AAT.
Okay. Why were they taken away?
You'd have to. It was a policy matter for the government.
Okay.
Can I just add to that, Senator? That we don't want matters to go to the AAT. We don't want matters in litigation. You know, if it's, I think the Commissioner said there's three areas matters to be litigated. One is where there's an important policy issue of law to be clarified for the general community. Secondly is where you've got egregious egregious conduct, where out of fairness to all other taxpayers, we have to ensure that that conduct that we'll take that on. And thirdly, where you've got the intractable dispute where someone wants a deduction for their bed socks or something, where out of fairness again to all other taxpayers, we can't let that one go. But otherwise, I mean, the whole thrust of our reinvention has been to avoid disputes.
And the numbers you gave us before go to that point, don't they? And compared to what you do.
The situations you're talking about are again in the past, but and I don't downplay them for a moment. I mean, the thing is that we do take these things seriously, but the thing is that we have introduced so many facets to our organisation to deal with pre-assessment disputes or post-assessment to avoid matters going into litigation. We have independent review for the large market. We have a fast, intensive triage process where objections come in and they're dealt with very speedily, so that taxpayers are contacted very quickly. There's more interaction with taxpayers. We have a dispute assist, which is to help taxpayers who are, through have had personal bad circumstances such as home violence or whatever, to assist. So we're trying to get away from going to the AAT.
And I accept
and
that.
in terms of deciding the objections, the objections area is already under an independent second Commissioner of Taxation who has no role in the compliance area.
Sure. And what we're talking about here is process, and I'm using that to illustrate the need for process. But there's a perception out there in practical terms that you are the assessor, then the judge, then the jury, then the executioner.
Well, I reject that. There is an assessment by the compliance area. Under a second Commissioner, Mr Mills, there is a separate objections area that independently determines any objection to an assessment. And then on appeal to the AAT, which is a no-cost jurisdiction, you've got someone standing completely in the shoes of the Commissioner making a new administrative decision over the matter.
So we have an internal separation. We have our objections, which are dealt with in the review and dispute resolution team, as against the audit team that do and we have strict communication protocols that have been established in the last couple of years, and that has worked. Now we're extending it to small business. So we're running a prototype for small business disputes. They're having this under a certain amount that can have before the assessment's issued, they can have it reviewed.
And that's good. And Chair, if I may, I've got one more series of points, then another question. But thank you for that. That's now on the record, and my constituents can look at that, and we can talk about that. I guess the problem that we have when we see the impact, the human impact on people of this, and I'm sure you're not immune to that either, is that, as I experience through the Department of Veteran Affairs, where the Department of Veteran Affairs has something like 47,000 successful compensation claims per year, it still has a small number of people from my background who are very badly affected by this process, and that's what I'm trying to get to. Gentlemen, in relation to the second question I've got, I go back to when Mr Joe Hockey, when he was Shadow Treasurer and Speaker of the National Press Club, said that he was aware that the ATO was sometimes committing criminal offences when pursuing the recovery of revenue, and that consequently he was going to split the ATO in that regard to prevent this occurrence, to establish an independent review process for disputed assessments. He was later apparently persuaded in his next job by the ATO not to implement reforms in that regard, and consequently some of the problems that we've been talking about today still exist from our point of view. In the case I quoted before, Pattenden case, he'd returned to Australia from New Zealand to deal with the matter. He was then involved in constructing a building in Auckland. After arrival, he was served with a departure prohibition order, preventing him from returning to New Zealand, and we've had similar cases, other cases this morning, from returning to New Zealand to attend to his business affairs, so placing him both in financial jeopardy and under huge stress. He was consequently stuck in Brisbane for 6 months, waiting to have his matter heard by the Federal Court, which he easily won, together with costs and compensation. Now, we don't expect you guys to be perfect by any stretch of the imagination, but there's got to be something in this. He then went to return to New Zealand after winning, before being served with another departure prohibition order at Brisbane Airport. He returned to the Federal Court, where the concerned judge became incensed at the ATO's behaviour at issuing the DPO. The judge threatened to issue arrest warrants against the ATO officers who had issued the DPO, so the ATO was then forced to withdraw the DPO. The ATO then pursued Pattenden to the High Court. Now, pursued that's an emotive word. At which time he voluntarily returned to Australia again to win his case again. An independent review of the ATO's Pattenden assessment of this case would have obviated those happenings and saved the taxpayer money, which is what I go to as the point at which the dispute attracts model litigant obligation. And my question is it considered that there have been grounds in some instances to criminally prosecute ATO officers for allegedly committing criminal offences in pursuit of monies sought from the raising of some disputed assessments? Have there been? How is that considered?
No,
not to your knowledge?
I have no knowledge of that.
No.
I suppose
And that is a particularly old case, and I don't really feel I can comment.
Since that case, then, have things progressed within the department?
Yes, I think definitely, because we do have that independent second commissioner determining whose area determines the objections now. Yes.
And the review and dispute resolution, which I'm part of, is about 700 or 800 people. They're the ones that do the objections.
Okay.
And they're separate. As I said, separate from the audit team.
Yep.
And there's a strict communication protocols in terms of them communicating with the audit people. And also transparency with the taxpayer, and in terms of empathy and with the taxpayers, I mean we've had a focus and President Commissioner in the past a great focus on personal contact. None of these 20-page, 30-page letters to the individual small business. We're trying to encourage personal contact, and we want to avoid disputes. We're about trying to avoid them. The question is, all the matters you've raised and it's been raised, how is this legislation going to fix that?
That's right.
That's what my concern is. We're not downplaying the concern. If there's been a breach of model litigant, there are many other avenues of redress, including if it's serious enough with legal practitioners. There's the law societies, and there's also the courts. I mean, but the thing is that the question is, how will this legislation deal with it? We're not trying to downplay the importance or seriousness of being a model litigant. The question is, how will this legislation deal with the situations that you've mentioned? And the court system has worked. The court system has worked.
And if I just make one more comment, if I may, before I hand over, please, back to the chair. The Pattenden case, was that something which caused the department to change to create your position and the 700 people working? How did you learn from the Pattenden case? Or was it examined in any way? Because you seemed, the department, ATO, seemed to get that wrong at every move.
Well, it's been part of the ATO reinvention program and the sort of comments we've had from Mr Hockey and various other people over time to move to this model. Yeah.
Okay.
And we listen to the community. I mean, this search for independence, and this is how it was set up. That we have a separate independent review and dispute resolution team that deals with the objections, and you know. Plenty of times we disagree with our audit people. We have to deal with that, and we'll allow an objection when it's been. You know, but we've entrenched that independence, and it's been acknowledged. And as I said, now we want to avoid disputes, and we're now moving into small business to have the independent review.
An independent review of a small business.
The independent review so small business going to get an assessment, but they can ask for an independent review before the assessment's issued. So that's the high.
Yeah, I've finished. Thanks. Yeah. Thank you very much.
Just before I get back onto the bill, do I understand that that you head up the litigation section? Is that right?
Yes. Yeah.
But you're also associated with part of the appeal section. Is that right?
The
objections?
No.
Objections.
Yes,
sorry.
Yes.
Yes, but I yeah.
So objections and litigation are together, and audits are separate.
Audits are separate. Yeah.
Separated.
Yeah. That's right, yeah.
Would there? My final question on this one is: do you think appeals and litigation are comfortable bedfellows?
Definitely, because I think to determine objections, it's very useful if you have some litigation experience and close knowledge of how courts see things.
Yes, okay. I get your point. All right. So just to be clear, your objections to the bill, which is what we're here for, are delays and costs, and your view that there is already existing provisions to deal with failure to comply with model litigant obligations. Am I understand you correct?
Yes, but added to that, sorry, but fundamentally, it's that it doesn't resolve the issue in dispute.
No, and nor is it intended to.
Yeah. Yep.
It's a purely procedural
No, I understand
process.
that.
It doesn't address the merits of the case.
Yeah.
But your concern is delays and costs.
In the procedure, because if the procedure relates to the determination of disputes, such as the means mentioned before about discovery and things, then obviously the court does have that jurisdiction already. The question is when it doesn't. When it doesn't relate to the determination of the dispute, and the process doesn't relate to the conduct going to resolve the dispute, then you will have you've set up a separate. Basically, you're conflating the determination of the conduct with the determination of the tax dispute, and that's where you're going to get the added cost and the delay.
Well, the way it's envisaged, it would operate is that a party to a dispute with the ATO would consider that the ATO's behaviour is adding to costs and delays, and that drawing that behaviour to the attention of the court may in fact help to resolve the case. So given that the onus for whether or not to invoke the options available under the bill would be with that party to the dispute, you would think that they would take into account their own interests as to whether costs and delays would assist them or harm their case.
I think with contemporary court practice, you would hope the court would already be intervening in those sort of circumstances, or the taxpayer would be taking that directly with the court.
The evidence we have is that does happen in some cases, but it's not inevitable, and we certainly have some egregious examples of where that's not occurred. I suppose if we were to accept your claim that the ATO is as virtuous as you say, you have nothing to fear from this bill, and that you may in fact be able to provide tutorials to the other departments that are substantially less virtuous.
Well, sorry, I don't think we're saying we're virtuous, and really, I think it'd be, I don't think it's probably right to say that we're looking at this from our own perspective. I mean, again, we're looking from a taxpayer's perspective also. Because it seems to us that it's the ordinary mums and dads that are going to be hurt by this, not the egregious taxpayers who'll take advantage of collateral attacks using this procedure.
In what way will the ordinary mums and dads be hurt by it?
Because if they want to make a model litigant, if the expectation is that they can apply to the court for a model litigant complaint, and it doesn't go to determination of dispute, their tax dispute is going to be put on hold with a stay, and the court and the Ombudsman are going to be determining whether there was a breach of the model litigant, which they'll have to establish.
And that will be a costly process. They'll have to have advice on that as well.
No,
and in the
Ombudsman
end,
doesn't charge a fee.
In the egregious cases, it's the taxpayer who will bear the very substantial cost of those sort of collateral procedural challenges.
The procedures envisaged in the bill don't involve cost. They do involve delay. They don't involve cost. Lodging an appeal with the Ombudsman, there's no charge involved in that. It's not a litigated procedure. The Commonwealth Ombudsman seeks the views of both sides and comes to a resolution or comes to a...
There are costs involved in developing those views in a litigation matter where you've got, say, external solicitors involved and a taxpayer makes a vexatious sort of claim. We're going to incur substantial costs in dealing with that.
And any appeals, I mean, obviously procedural fairness to both parties. If one party disagrees with the decision, then there's going to be an appeal.
There is no decision. There is no decision by the Ombudsman. There is no decision by the Ombudsman. It's advice to the court. It reverts to the court in which the case is being heard. The only thing that's occurred is that the case has been put on hold for 60 days while the Ombudsman comes to a view as to the merits of the complaints about failing to comply with model litigant. I'm not sure where you're getting to.
Then if the court comes to it, so what relief can the court grant? I mean, the court would, if the court says there's been a breach and the commissioner disagrees, or the court says, yeah, no, there hasn't been a breach and the taxpayer disagrees, one party will probably appeal. I mean, it sets up a whole...
There is no provision for that. I mean, it goes back to the original court. It goes back to the original court in which the matter is being dealt with. I think it's easy to envisage a situation where one side makes assertions as to the poor behaviour of the other side, and the other side being a Commonwealth body. The judge is in no position, the court is in no position to assess the merits of it. Has a full caseload to hear, would find it incredibly helpful to be able to receive advice from the Ombudsman as to the merits of it. Yeah, I can easily imagine a judge saying, yes, thank you very much, I will accept that as a source of advice, comes back to the court, the Ombudsman said, nothing to see here, and if it is a vexatious situation, as you're suggesting may occur, that may well reflect poorly on how that party is dealt with by the judge.
But the court's going to have to give the Commissioner procedural fairness. So if the Ombudsman comes back with a submission saying a view that there has been, well, the court will obviously give the Commissioner, will want to hear from the Commissioner, so there'll be submissions, there'll be a hearing.
There's no provision for that in the bill. It's a matter for the Ombudsman. The Ombudsman would talk to the Commissioner or people in the ATO and would talk to the complainant and provide advice to the court.
But
that's the point. It's exercising federal judicial power.
Yes.
It has to give the Commissioner procedural fairness.
It's not exercising power at all. All they're doing, it's a friend of the court position.
Yeah, but it can't.
Well, I think there's a lot of complexity here we haven't got into, and I know we can't really speak for what a judge would say about this, but.
I think that would have constitutional implications. Actually,
judicial power of the Commonwealth, and it's going to have to determine its proceedings in accordance with those principles.
Otherwise, it wouldn't be exercising. It'd be exercising administrative power, not judicial power.
There is no power being exercised. So anyway, I understand your objection, so that's all I needed to know. Thank you.
Yep. One more question.
One more question, sorry.
before we must move on.
I understand how departments change and how improvements to departments change, and I've seen that in Veterans Affairs. And a lot of the tension and stress built up on individuals is slowly being mitigated as the department changes its culture and improves, and that's changed. Would you be prepared to meet? How are you publicising the fact that you have changed internally? Is it common knowledge? And I just don't know about it. I'm sorry. I have had no problems until now with the tax department.
Well, yes, we've published. I think you're probably better to speak to this, but there's material on our website. We've published brochures. We've given talks at various places. We have a pilot program with the university. All sorts of things. And
we've also had what we call the fairness surveys to go back to people to see how they've thought they've been treated.
Good. I just have one final question, and that is: would you meet with Mr. Shaw, not on his case, but on the changes to explain to him that you are a reinvented and a better organisation? If he was happy to meet.
Absolutely.
Thank you very much.
Yeah.
Just finally, just to set the record straight, are you quite sure Ms. Helen Pattaya released that letter?
Yes, she sent it to the chair of the committee, and the chair and one of the committee members tabled it, not us.
Okay. My impression was the commissioner did, but
no,
you weren't here. It was during the estimates during the week. All right, I'm finished, Chair.
Okay. Well, look, thank you very much, gentlemen. We do appreciate your assistance, and as I say, you have a difficult job, which we understand, but we do appreciate your comments on this bill.
Thank you, Senators. Thank you.
Thank you. Thank you. We now call the Attorney General's Department. So what's the significance of this?
This was submitted to when the ATO was appearing before estimates during the week. You wouldn't have been there anyway because you would have been legal in Colin. And it's a massive apology for the ATO having made a massive cock-up of a taxpayer's case. Something like 7 years it took her. And it's still not settled. She's now seeking compensation, which isn't settled, so that's the remaining outstanding. And when they get it wrong...
Was that
It may have helped. My feeling is that the bill would have a educated. I understand.
Welcome, Mr Anderson, Mr O'Brien, Ms Whittaker from Attorney General's Department. I make the same comment to you as I did about the Ombudsman. We should get you an office in this building so you don't have to walk far for all the committees you attend. But thank you for your appearance. We have your submission. Did you want to add to that in a short opening statement?
I would like to.
Yes.
Ian Anderson, Deputy Secretary, Legal Services and Families Group, Attorney General's Department. I just want to say that the legal process is potentially inherently disempowering and alienating. Bureaucratic processes can similarly be disempowering and alienating, and at the same time people can certainly feel they can have a different sense of fairness to the substantive impact of laws enacted by Parliament. So there's a number of reasons why people can feel aggrieved, hurt, feel that they're being treated unfairly, even though it might be in accordance with the legal process, in accordance with the appropriate administrative practice, in accordance with the laws of Parliament. There are a number of different options and remedies available where people feel aggrieved or that they've been unfairly treated. Obviously there's internal review, so that the Commonwealth makes millions of administrative decisions that affect people's rights, each year, of those millions of decisions, people can seek internal review within agencies. If they're dissatisfied with the internal review, they can then seek merits review by the AAT, and the AAT had 58,000 matters referred to it last year. If they're dissatisfied with that, they can send appeal to the courts for judicial review. So there's a number of formal legal avenues available. Then, of course, there's the Ombudsman. If people feel that they have a grievance in terms of improper or unfair administrative practice, in terms of how a legal process has proceeded, there's the Office of Legal Services Coordination within the Attorney-General's Department, and that administers the legal services directions, which are legally binding to all Commonwealth agencies and departments with respect to the model litigant obligation. For people who feel that they have suffered detriment due to the miscarriage of administrative action, there's the compensation scheme, the compensation for detriment due to compensation for compensation for defective administration. Yes, detriment due to defective administration. If people are in litigation in a court, the courts have inherent powers to control the matters before them, and those inherent powers include the ability to stay proceedings if there's an abusive process, if a party is not complying with directions, is failing to answer interrogatories, all of those things the court has the power to actually regulate. When legal practitioners are involved in a matter, they have separate obligations as well, professional obligations, and including obligations as officers of the court, and courts have powers to personally impose cost orders on the people who appear before them as representatives, and then there can also be, people can be struck off if necessary if their professional behaviour is not appropriate. For the absolutely most egregious cases, if people feel that there has been some deliberate action to harm them, then there's a question you can actually sue for negligence or misfeasance. Now, obviously there's an evidentiary burden in seeking to establish that you have been deliberately harmed by officers of the government, but those are also options that are legally available, and there have been such suits brought and on occasion successfully brought against governments. The committee's heard a lot about tax, the conduct of the tax office. The ATO is only one agency, it's a big agency, and they do quite a lot of litigation, a lot of decision making, but it's only one subset of the total of the Commonwealth engagement with citizens in terms of making legally binding decisions about people's rights and interests. Much of what you've heard has actually not been about litigation, it's been about administrative actions separately. You have, however, heard about, for example, I think the Small Taxation Claims Tribunal was mentioned a little bit earlier. That was a division of the Administrative Appeals Tribunal, ceased to exist with effect from 1 July 2015 when various other tribunals were merged with the AAT, but there is obviously the ability for government to consider that sort of arrangement, to consider special ways of dealing with tax disputes if that was desirable. There is a separate tax division, tax and commercial division of the AAT, and the President of the AAT can issue practice directions saying that tax matters should be dealt with in a particular fashion. And it's my understanding that the majority of tax matters before the AAT are in fact resolved by the application of alternative dispute resolution processes. But at the same time, you need to bear in mind that the AAT, you can have matters that range from a small individual taxpayer through to a transnational taxpayer with a very large commercial taxation dispute. So, but it is possible to treat different types of taxpayers differently before the AAT, for example. While you've heard from a number of, in terms of submissions and evidence, you've heard from a number of people who've said that there's a need for something such as this bill. I just obviously note that the Law Council of Australia said in their submission that they don't think that this bill will in fact bring anything that's going to be helpful. And also the Victims of Abuse in the Australian Defence Force Association said that they don't think that this bill is necessary or desirable, and they think that the Attorney-General remains the appropriate person to deal with these sorts of concerns, model litigant concerns. We've put before you that we think that the bill is not necessary because there are these existing powers of courts, etc., and these existing other schemes. We haven't seen in administering the legal services direction since 1999, we haven't seen any evidence of systemic abuse by Commonwealth departments and agencies. We have seen occasions where there have been breaches of the model litigant obligation, and we believe those have been remedied and that agencies have taken those on board, but it's very small numbers compared to those millions of administrative decisions being made each year that impact upon people's rights and interests, and those 58,000 matters in the AAT last year, for example. Certainly, we think that if the bill was to be enacted, it would lead to model litigant obligations being raised in the way that the bill envisages. We think that that would in itself be a burden on courts, because the courts would have matters that would take longer before them. It would be a burden on the Ombudsman as well, because the Ombudsman would need to consider the matters. We think that there's a lack of clarity as to what would happen when the Ombudsman actually reports back to the court. The court has the ability under the bill to make an order, but what if the court says, OK, we need more information from the Ombudsman? What if the court and the Ombudsman, court doesn't agree with the Ombudsman's findings? While it was said in relation to the ATO evidence that there's no appeal mechanism here, if the court does make an order, which the bill would gives them the power, then there could be an appeal from the making of an order by a court. So there is a prospect of potential for appeals there. But I guess the fundamental issue for us is that it's not necessarily going to assist with the people who have a concern or a grievance or are upset about how the application of the laws or how the application of administrative process has unfolded in their particular case. Because our findings are that while we get a relatively small number of people alleging a model litigant obligation, it's a very small subset of that actually has a breach. So we think there would be people who would be very sincerely believing that there's been a model litigant breach in their case. They would they'd raise that concern, the court can stay their matter, the Ombudsman can look into it. We don't think it's necessarily going to actually change their position at all. So that's what we would say. I guess, in answer, one of the final point is, if those people do already have the ability to raise their concerns with the Office of Legal Services Coordination, we can look at their matter in the course of their litigation, and I'm certainly aware of situations where the department has got involved with another agency and said, we think you need to do something in the course of this piece of litigation.
Okay.
Thank you.
Mr. Anderson. Look, can I just start with just a couple of questions? And it's a matter I've raised. I think I wrote to the attorney about the live cattle export case.
Yes, you did.
And the attorney wrote to me, and you may have assisted the attorney in preparing the response. We've had evidence, which so far is in camera this morning, about the same issue. And a number of issues raised, like a failure to act on discovery within the time limited. Now, sure, the courts, you can go back to the court and ask them to do something about it. But a model litigant wouldn't allow that to happen. Now, as I say, the attorney wrote to me when I raised these general objections. I forget the exact nature of his response in relation to that. We've also heard today that the Commonwealth's lawyers have insisted that the plaintiffs prove the international impact of the ban on other countries, namely Indonesia, when it's almost impossible for the litigant to prove that, but it's a well-accepted thing within government circles that, Indonesia were disadvantaged, to put it politely. And yet, apparently, according to the evidence we've received today, which, as I say, is currently in camera but may not be in the future, the applicant's been required to prove that, which the only proof is with the defendant, and yet the defendant is making the applicant prove that. Now, that hardly seems to be the activities of a model litigant taken in the broad. Now, with all these things, there's always another side to the argument. I always appreciate that. But, those two things seem to be a very obvious case of the Commonwealth not being in lead. It's almost as if the individuals involved feel that it's their pocket or their reputations that are at stake, so they're fighting as one would do in a normal commercial activity. And this bill may not be perfect, but it's an attempt to in some way address those sort of things. But can you sort of, and I think we have been through this before, but if you can just remind me what the response is to the very obvious claim, you either answer discovery as required, or you don't, or you do it in time, or you don't, or you do it in a way that you redact everything that makes it just meaningless. Are you sufficiently familiar with that case to comment on those? And also the one about the applicant having to prove the impact on the Indonesian economy.
Senator, I might start with the second one first, and without obviously the benefit of hearing the evidence from this morning. I mean, if a party is raising a particular issue in a dispute, and it's a matter that the Commonwealth knows the truth of, effectively, I'm summarising here, paraphrasing here, then under the model litigant obligation, under the legal services directions, the Commonwealth shouldn't be putting people to proving things that the Commonwealth agrees are in fact true or that are not in fact in dispute. But at the same time, a party raising a matter in litigation does bear the onus. So, again, without having heard the evidence this morning, I'm not sure how the party seeking to raise this question and whether they've been asked simply to provide some evidence to support submissions or whether they've actually asked to formally prove the impact in Indonesia. I just say that there's nothing inconsistent with the model litigant obligation for the Commonwealth to put another party to proof of the submissions it's actually raising, providing that it's not something that the Commonwealth actually knows itself is already true.
That was the assertion. Yeah, that was a known fact.
And it was a known fact. But the only ones that could prove it exactly were the Foreign Affairs Department and the interaction with the Indonesian government at the time, which I happen to know was severe and extensive. And yet the plaintiffs are being asked, according to the witness, now I might add the witness was not a lawyer and is not a direct party to the application, and I think the evidence will be made public because there wasn't a lot in it that we all agreed, including the witness, needed to be taken in camera. So if it does come out, you could perhaps look at that and perhaps on notice give us a response to that. But I think the way I've articulated and the way Senator Leyonhjelm has confirmed that it was put, that seems to be a classic case where if it was a commercial dispute between me and him and you know, I was taking every point, that's the point I'd take. You prove what the Indonesian government thought. You know, I'd do that in a commercial dispute between him and me. But when it's the government taking that seems to be contrary to the principles of model litigant. Now, these would be a very small number of cases, I appreciate. They're important cases, and hence it's, I assume it's been the formative part of the reason for this private member's bill.
So, Senator, I mean, going back to that second part of your question, if what's being required is some evidence about the impact then of those parties who gave evidence this morning, the impact on them of this through the impact on the Indonesian market, that would be something that might be required to be the subject of evidence that they would put forward. But if it's what's being if what is being asked is they're being asked to prove the impact on Indonesia, that I agree that would be a separate thing. But there's not necessarily an issue with the Commonwealth saying we need to understand through evidence what the impact has been on you if you're claiming damages, etc., from the ceasing of the
again,
live.
that was almost self-evident if that was the case, but it wasn't the case.
The quantification of the damage is something that would be uniquely known to them, I would have thought, and not necessarily difficult for them to put evidence.
That's something you'd think that you'd have a mediation on. The parties would sit down and say, let's work out, not concede that you're right or wrong, but let's work out if you were right what the cost would be. But I think, as I recall, another of the complaints was that any requests or suggestions of a mediation, sit down, work this out of court, have just been rebuffed by the Commonwealth now.
So I will say in relation to the first part of your question, Senator, about the discovery, failure to comply with the discovery, so that's a matter that is inherently within the court's powers to control. But when you first raised this particular issue with the attorney and the department looked into it, my recollection is that there have been failures to comply with court orders on the part of the people who gave evidence this morning, and that can have a consequential effect upon the Commonwealth's ability to comply with court orders. If one party is running late, then that might mean the Commonwealth then is forced to run late as well. So I just think in this particular case, and without having heard the evidence this morning, my understanding is that the Commonwealth believes that in fact the fault has actually been on the other side in terms of complying with court orders.
So,
Yes,
Mr. Anderson, I guess the issue is this, that there are, notwithstanding an awful lot of litigation which doesn't give rise to complaints of bad behaviour in the process, there are nonetheless significant examples, and the one we heard about this morning sounded particularly egregious. So the list of assertions of bad behaviour was, as you heard, a refusal to participate in alternative dispute resolution, failure to comply with discovery orders on a number of occasions, claim of public or inconsistent claims of public interest immunity, claims of public interest immunity where the information may assist the plaintiffs but not the defendants, substantial redactions, and also using technical points, in particular seeking to force the proving of known true facts. Now, in the current situation, both you and the ATO have said, oh, but there is recourse available. And essentially what they refer to is you raise that with the judge hearing the case. So, and that these matters are brought up in courts, quite often, especially failure to comply with discovery, for example. You can have cost orders, as I'm sure you know full well. Nonetheless, the courts are busy, they have busy schedules. Hearing these issues, these things on the side, can be quite inconvenient, and sometimes they may not be particularly well argued either. So your argument and the ATO's argument is essentially there is no need for the Model Litigant Bill. There's no need for it. So my argument, or my question in response to you would be, if there's no need for it, then it won't do any harm. And even if, there's 4 cases a year in which it's influential, and the one that was mentioned this morning sounds to me like it might be of some assistance to them, isn't that positive? Isn't that a net positive?
Senator, I'd go beyond saying that the bill's unnecessary, and I'd say the bill would in fact cause harm. I think that the bill would hold out to people the prospect that they will get the Ombudsman and the court addressing their underlying sense of grievance or having been unfairly treated. And I think that it may be that in one case, as you say, the Ombudsman and the court would say there's been a failure to behave properly by the Commonwealth. But I think there would be a number more cases where the Ombudsman and the court would say, no, we don't think that there's been any issue that causes us to do anything other than say, let's get back to dealing with the resolution of the substantive matter. And in the interim, there will have been a process. I expect that there will have been some cost to those involved, even though, as you pointed out earlier, there's no fee to apply to the Ombudsman. There may well be a cost in having legal representatives or indeed just a cost in preparing submission to make to the Ombudsman. And there's also the fact that if it doesn't do anything to change the position of the person, I think that would also be difficult for them emotionally and otherwise. So I think
why is that an objection if it's up to the non-Commonwealth side in litigation to decide whether or not to invoke the model litigant complaint, knowing full well that if their claim is frivolous and the Ombudsman goes back to the court and reports the claim is frivolous, that may adversely affect their case. I mean, wouldn't that tend to filter the frivolous ones out pretty much?
So there's no detriment to the party if they make a frivolous claim.
Except that the court can take that into account because it reverts back to the same court.
To use the example raised by the ATO, the court's not going to say you made an incorrect or frivolous or misguided claim about the breach of the model litigant obligation, therefore we're not going to consider your claim to a deduction under the taxation laws. So I don't see there's actually going to be any repercussion there in terms of the substantive dispute. As a matter of public interest, though, I think it would the fact of the bill would encourage people to make claims. Not all litigants against the Commonwealth necessarily have clean hands, and I think that there would be a burden upon the Office of the Ombudsman in considering the complaints. I think there'd be a burden upon the courts, which, as you said, are busy. So I think that it seems like if indeed there's one case that it might be assisted through this, I think there'd be a number of other cases that wouldn't be assisted, and there would be, I think, it wouldn't be in the public interest for there to be the financial and other burden of those other cases being raised. But that ultimately is a matter for Parliament.
I'll grant you one point. It will be a burden on the Ombudsman. I will grant you that point. But I would have thought a court in which a procedural complaints about the Commonwealth's behaviour was raised would find it a relief if they were inclined to take it seriously, if they thought on the face of it that it might be legitimate, would find it a relief to say, OK, I'm going to grant a stay for 60 days and I will await the Ombudsman's advice and then make my decision as to what significance I place on that claim with the benefit of the Ombudsman's report. I would have thought a court would find that pretty beneficial.
I think, Senator, from memory, it's 60 days or such longer time as might be agreed between the Ombudsman and the applicant. But that's not a very...
Yeah, well, I'd have to check. That's my bill, I know, but I don't remember.
Yes. Again, in terms of the necessity of it, there's nothing to stop someone who has a grievance currently in the middle of their litigation or preparation for litigation going to the Ombudsman or going to the Office of Legal Services Coordination and raising their concern. So if they can already raise their concern with the Ombudsman at that point in time, the bill will enable them to raise it with the Ombudsman at that point in time again. So I'm not sure...
What would be the consequences, suppose, of a plaintiff in a dispute with the Commonwealth in which the Commonwealth has engaged external legal representation who are oblivious to, unaware of, whatever, of model litigant obligations, treating it as a normal commercial dispute that they might deal with for any other client. If that plaintiff lodges a complaint with the Office of Legal Service, OLSC, whatever it's called.
Legal Services Coordination.
Yeah. What would be the consequences of that? Or even going to the Commonwealth Ombudsman under, as you mentioned just before. I would have thought totally ineffectual.
Well, both the Office of Legal Services and Coordination and the Ombudsman would have the same response, which is to seek information from the agency that's been complained about as to the complaint. The agency would have to engage with that process. If they fail to engage with that process, then that can lead to the drawing of inferences in itself. So the agency would be expected to engage with that process. In the case of the Ombudsman, for example, they can make a range of recommendations as to what remedy should be afforded to the person. In the case of the Office of Legal Services Coordination, they can also tell an agency, we think you should do something differently if we think that the complaint that's been made has grounds.
Are you aware of the Commonwealth Ombudsman ever doing that in a complaint about failure to follow model litigant rules?
I'm aware of complaints having been made to the Ombudsman about model litigant issues, but I'm also aware of, the Ombudsman receives a large number, I'm trying to think how many it is, 46,000 or more complaints last year alone. And the complaints are not necessarily going to be, solely dressed up as model litigant complaints. Effectively, at their heart, they're about inappropriate administrative action. So the Ombudsman will look at that. I shouldn't necessarily speak for Mr Manthorpe, but the Ombudsman's office, as I understand it, will look at that matter and say, is there something there that we need to look at? And their first step is generally to seek information from the agency that's been complained about.
I wonder whether that would occur, considering his lack of enthusiasm for this bill based on just, the implications for his workload, I think. that he expressed earlier today. I wonder whether he's actually, let's suppose this bill doesn't pass, but a party to a dispute with the Commonwealth somewhere reads your evidence today and says, "Oh, I didn't know I could do that," and complains to the Commonwealth Ombudsman about the behaviour of the Commonwealth in the case in which they're involved. My suspicion, based on what I heard this earlier today, was that the Commonwealth Ombudsman would say, "I've got so many other things that I have to worry about. I'm sorry, I'm not going to get involved in this."
So I probably shouldn't speak for the Ombudsman and how they would deal with the complaint when they receive. My previous remarks were just about the system in terms of the ability to make complaints to the Ombudsman and how I understand that they do then engage with those.
Yeah. So I guess my point is that I don't think it would do any good to do that for a party to a dispute, whereas if they were able to ask a court, can I please have the Ombudsman investigate my arguments that the Commonwealth is behaving poorly, and the judge says yes, okay, then the Ombudsman is involved, no matter what he thinks he might have been his position had he had no choice. So I'm struggling to see how that's necessarily a bad thing.
Well, I'd come back, Senator, to the fact that when we've investigated allegations of model litigant breaches, we've found very few of those to in fact be sustained. Mm-hmm. Even in the cases that are sustained, many of them are actually relatively minor in terms of the behaviour that's been involved. They're not necessarily all of the worst degrees, but we still record them as being breaches if they strictly don't comply with the obligation. And so I don't think that that extra burden upon the Ombudsman, burden upon the courts, and indeed potentially raising the hopes of parties who might be legitimately upset with government but who might actually substantively not have a reason other than a grievance about how the legal process operates, how the administrative process operates, how the substantive laws actually operate, that they might not actually have a model litigant grievance when it's actually examined.
I understand your point. I guess the same question could be raised in relation to the OLSC, which has been mentioned by a number of in a number of submissions. Suppose a party to a dispute contacted the OLSC and said, I think the Commonwealth is not complying with the Model Litigant Rules. I mean, what remedies are they likely to receive?
So it depends upon the nature of the breach. I mean, if that's alleged. I mean, if it's a question of not complying with the procedural orders of the court, and we agree that the party is not, that the Commonwealth agency is not complying with the orders of the court, then we would be taking steps to make sure that the Commonwealth agency did comply with the orders of the court, and we'd be asking them why they haven't. We wouldn't necessarily be imposing a further penalty, but we'd be seeking to have them comply with the orders of the court, and there are ways in which that can be done if necessary. The Attorney can issue directions, for example, as to the conduct of an agency in a piece of litigation. The
Attorney can do that?
The Attorney can issue directions, yes.
All right. I think I understand the objections of these folks. If you don't have any more questions.
Okay, thanks very much. And nobody else has any further questions. Thank you again for your attendance, and we do appreciate your assistance. With that, with thanks to Hansard and the Secretariat, and to my colleagues Senator Pratt and Senator Marlin and Senator Lionhelm, I'll declare this hearing adjourned.